Good morning, everyone. I am Ernesto Bird, and I'm the publisher of New Hampshire Business Review, and it's my pleasure to welcome you to our webinar today, Plan Well, Live Well, Estate Planning for Business Owners and Managers. This webinar is sponsored by Ledyard Financial Advisors, and our expert panelist today is Valerie Neville, Senior Financial Advisor and Fiduciary Consultant with Ledyard Financial Advisors. We will be taking questions through the Q&A function here throughout, but we won't be answering them until the end. So please feel free, as questions arise, to put them into the Q&A module, and we will be taking those questions at the end. And now let me bring Valerie to the screen. Valerie.
Hi,
Welcome.
Ernesto.
Hi,
Thank
Valerie.
you.
Thank you. I will now step away, and the stage is yours.
Okay. Well, we have a lot to cover today. So, as Ernesto said, um, I just think it's best to have a questions to the end, and I will get started. So today we're going to talk about estate planning for business owners. And the first thing I'm going to talk about is the stages of life and sort of how early do you need to start an estate plan and when do you need to update them. I'm also going to be talking about the 4 estate planning documents you should consider and what happens if you don't have them. And then I'm going to talk about the 5 ways to title your assets and the 4 ways to avoid probate. And finally, we're going to look at the cost of doing nothing. So as you're starting early in your career, you're in the accumulation stage, you may be starting a business, you may be looking at buy-sell agreements or exit strategy planning. You're looking at budgeting for yourself and your business, having emergency funds. If you have minor children, you might be looking for college and retirement savings, and obtaining insurance for those minor children. And at this point, from the estates planning perspective, you really, if you have minor children, you really want to have a will, because in the will, you name the guardian of your children. So if you and your spouse are gone, you really want to have something in place as to who's going to care for them. And the other estate planning documents are important as well. You know, you do have assets, so you will want to have a will. You will want to have probably a healthcare power of attorney and a durable power of attorney. In the mid phase of accumulation, you're really looking at, potentially having adult children and a growing business. You're really sort of focusing on cash flow planning as you're growing, and maximizing those retirement contributions. From the estate planning perspective, you want to make sure your adult children have a healthcare power of attorney. That is a document that you cannot get private healthcare information on your children when they're adults unless you have that document in place. Towards the late phase of accumulation, you may have a very mature business and grandchildren. Again, you want to look at maximizing your retirement savings. You may want to be looking at 529 planning for grandchildren, for their college, and business succession planning. And at this point, you're really looking to really update your estate plan, considering get a trust. And then as you move into the next phase of retirement, you're looking at potentially selling your business or perhaps passing it down to the next generation. For yourself personally, you're looking at cash flow planning for retirement. How are you going to live now that you no longer have the income? And how are your resources going to sustain you? And then if you have significant assets or a big tax bill due to potentially selling the business, you may want to look at some charitable giving strategies. So as I've mentioned during the stages of life, you really want to have a estate plan, from the very beginning, but you do want to tailor it and modify it and recheck in as the years go by. So I've mentioned the four estate planning documents that you need to consider. And these are listed here, and I'm going to go over each one in more depth so you get a sense of sort of how they work and how they can be beneficial to you. So I always start with a healthcare power of attorney or healthcare proxy because I think this is probably one of the most important documents. Um, a healthcare power of attorney is a document where you select an agent to carry out your healthcare decisions in advance in the event you're unable to do so. But as I previously mentioned, it also enables you to get private healthcare information. With the HIPAA laws today, that information is hard to come by even for spouses. So it is an extremely important document to have. As far as where to get it, it is a document that's state specific. So you will want to make sure you have a healthcare power for whatever state you live in. Sometimes you can obtain these from the hospital, or maybe there's a state repository for them, and they are a pretty standard form. If not, the attorneys do generally draft them when they draft the other estate planning documents. If you don't have a durable power of attorney for healthcare and something happens to you where you become incompetent, or you enter into a point where you're unable to communicate, then your family will be forced to go to court to have a guardian appointed over you. And basically, they will have to prove your incapacity in court, which is very public forum. So it is a good idea to have one of these. It's very unlikely that these scenarios turn out, but you don't want to be the one case where that happens. It is important to consider who you're going to name as your agent to make your healthcare decisions. So you ideally, if someone has some medical knowledge, that's great. Most people don't have someone like that in your family. You do want to have somebody who will follow your wishes. And I think that is the most important criteria, whether you want to have life care extended or you don't, whatever your wishes, you want somebody that will follow them. And that can be difficult to do, particularly in a family situation, because, for example, if you say, I would like to discontinue care, and your agent is in the position to do that, other family members may not agree or may not understand that's truly what you want. So it is a good idea to have a conversation with your entire family about what those wishes might be. As far as where to keep the healthcare power of attorney, you may want to give it to your agent so they have it when it's necessary. If you don't want to give it to the agent because you don't want them to have your confidential information at this point, you could leave it with the attorney to hold on to and to release. If you don't want it to be active, only in the event you become incompetent, the attorney can draft what's called a springing healthcare power of attorney that is only effective if your doctor deems you incompetent. So you could, if you have one of those, you could give them to your agent, and that agent would be responsible for contacting your doctor to find out if you are indeed incapacitated. The next document I'm going to talk about is a durable power of attorney. And a durable power of attorney is a document in which you formally select an agent to carry out to manage your money and your property and your financial matters if you become disabled or incapacitated, or perhaps are just unable to effectively manage your financial matters yourself due to some infirmity or age-related problem. Some people also use it if they, for example, go out of town for 6 months traveling. They could give their agent the healthcare power, and that agent can pay their bills and take care of things. So it isn't necessarily a document that you have to wait to activate. You can activate it early if you want. Basically, the durable power of attorney is only valid while you're living. The minute you pass away, it ceases to exist. And so long as it's a durable power of health of attorney, it will continue on your incapacity. The property it covers is specifically everything that's specified in the document. And some states like Vermont, you really do have to specify everything it covers, because if it's not in there, then it's deemed to not be covered. And New Hampshire is sort of the reverse. A durable power of attorney can give you all powers except for those you specifically exclude. So they are very state specific, and you will want to have an attorney who's licensed in the state you live in draft that for you. If you don't have a durable power of attorney and you should become incompetent, basically your assets are frozen until a conservator can be appointed to handle them. And that, again, is a court process where your family goes to court, and perhaps one of them applies to be a conservator, but has to be appointed by the court. So it is really a good idea to have one of these in the event something might possibly happen. The duties of the agent are important. Essentially, they cannot commingle your assets with their own. They have to keep them separate. They manage the assets. They need to provide an accounting to you if you're incapacitated when you recover. They need to keep good records. They handle all of your finances, and the durable power of attorney often also extends to other issues like being able to legally go through your mail and handle other matters, within your house and your care, all sort of matters other than the health care. Naming your agent is a critical decision. So obviously you've got to name somebody that's completely trustworthy, because a durable power of attorney has complete legal authority over your assets. And, they are subject to being sued for breach of fiduciary duty if they overstep their bounds and use them personally, but you don't want to be in that situation. So you do want to select somebody that's trustworthy. Ideally, that person would also be financially savvy and able to sort of handle your finances. It is nice to have somebody local, and that too with the healthcare power, because they are available to go, to the bank or to the hospital. But you don't necessarily need somebody local. It can be done by sending documents through the mail and talking over the phone. You do want to consider naming a successor to a power of attorney. They don't typically put it in the same document. The lawyer may have you do two durable powers, one for who you want, and then one only to be released if that person can't do the job for some reason. And then where to hold it. The durable power, a copy of the durable power is effective. So you really don't want to release this unless you're going to use it. You can give it to your attorney if they'll hold on to it and release it for you. Often it'll put in there that it's not effective until you have a health issue, but if you do that, then that negates the ability to use it when you go away for 6 months on vacation. You should consider putting it in a fireproof safe at your house or a bank box. But if you do that, you do want to make sure you have a co-owner or somebody who has access to that and can retrieve that document if it's needed. The next document I'm going to talk about is the will, and most people have heard about a will. Basically, a will is a document in which you name an executor who coordinates the final distribution of your assets and in which you can name a guardian for your minor children. The property it covers is everything in put in your individual name. So for example, if you have a retirement account and it has a beneficiary on it, that goes according to your beneficiary designation form. It's only assets that are in your individual name that are covered. If you don't have a will and should die, a couple things happen. First of all, since you haven't named an executor, the court will have to appoint an administrator. Potentially, this could be a family member, but they might just assign somebody that is within the court to deal with this and appoint them. So it may not be somebody you know, or certainly somebody that knows about your wishes. The other potential problem is that if you don't have a will, your assets go to the laws of intestacy in the state you live in. And the intestacy laws are different from state to state. So, for example, in some states, if you're married, your entire estate would go to your spouse. In other states, maybe half would go to your spouse and half would go to your children. Typically, it is your closest relatives that the intestacy statute gives to, but they may or may not be in a amount that you would want. For example, in some states, even the parents would inherit, even if you have a spouse. The duties of the executor are similar to the power of attorney in that they deal with your finances. There's no commingling of assets. They manage the assets, and anything they also will have to file in a court accounting and file documents with the court, which I'll get into later. Naming your executor, again, you want somebody trustworthy, financially savvy, ideally local, certainly a capable person. And if you don't have someone in your family that fits this bill, you can hire a professional executor. For example, lawyers sometimes serves, or banks like Ledyard. And it can be nice to have an attorney because there are a lot of legal documents that you file with this, and most executors hire a lawyer to do that anyways. And as far as where to hold this, it is extremely important that you keep the original document somewhere safe, because when you pass away, only the original document can be filed. If it's not found, a copy doesn't do, because the court assumes that if the original doesn't exist, that you have intentionally destroyed it, and that you no longer want those as your wishes. If you live in Vermont, you can actually file the document with the probate court in Vermont. If you do a codicil, which updates the will, you will want to file that as well. If you name an executor that's a professional, you could leave the documents with them to be used when you pass. And the final document I want to talk about is the revocable or living trust. So a revocable trust is a legal document in which you name a trustee to control your assets, and you set out instructions in your trust how your assets will be handled when you die. If you fund it during your lifetime, it can help you avoid probate, which is why it's often called a will substitute. During your life, you can name yourself as trustee so long as you're able. You could also name a co-trustee to work with you. So for example, you might want to be a trustee and have, a bank like Ledyard Financial Advisors as a co-trustee. You will also want to name a successor trustee to take over when you're no longer able to age or infirmity. And because the revocable trust is revocable. You can change it at any time by doing a simple written amendment. So the property cover it covers is anything that is titled in your trust. So for example, if you have a bank account, if it's in your individual name, it will go according to the terms of your will. But if you reach out to the bank, give them a copy of the trust and ask them to retitle it into the name of your trust, that bank account will be in your trust and go according to the terms of your trust. The benefits of having a trust are many. So first of all, it covers both life and death situations. So if you have a trust and your assets are in a trust, for example, you don't have to rely on that power of attorney document so much because you've got a trustee you named who's managing your assets, and your assets are all in your trust or mostly in your trust. If you do it appropriately and get everything in a form that is not in your individual name, which I'm going to talk about later, you can avoid probate. So that is another benefit of having a trust. It is also private. Many people aren't aware, but a will is a public document. The accountings, your executor files are public documents, and anyone can look at these. The trust is completely private with no court involvement. There are more flexible distribution options because you can have continuing trusts or have the assets go out at certain times, like when your kids hit certain ages. For example, I have my trust set up so that my kids get a third at 25, a third at 35, 30, and a third at the final third at 35, because I figure if they blow it the first time, at least they get a couple more chances. The duties of the trustee are extensive. They manage your assets. They need to provide notice and statements and accountings to the beneficiary. If you've named a trustee and you're still living, they will provide them to you. If not, then to the beneficiaries that take at your death. They manage and custody the assets. They provide guidance and distributions to the beneficiaries. They file state and local tax returns, and they distribute the assets and terminate the trust at the time the trust finally terminates. I find in terms of naming a trustee, you want somebody that's trustworthy, financially savvy, ideally somebody that knows the family. You might want to name a co-trustee, say have a family member as one trustee and a professional as another trustee. And you do want to name a successor trustee to take over when that original trustee can't. For example, if you're the trustee when you can no longer do so. And in terms of selecting somebody, it is a lot of work. I mean, many families will turn to me and say, well, if I name one child, the other children are going to be upset because, this is an honor, and the other children do get upset. But I try to explain to people it is not really an honor to be a trustee. It is a lot of work. So you really want somebody with the attention to detail and who has good follow-up. And as far as where to hold the asset, a copy is deemed valid, so you can have copies. And since you are intentionally putting the property in during your lifetime, it is a document that you would want to have the trustee and the successor trustee have copies. You might want to have copies, you will have copies anywhere where you put your account in the name of the trust. Your attorney will probably have a copy as well. You do want to hang on to the originals, so you could put the originals in the bank box, but you can deal with the trust as a copy. So as I've gone through here, we've sort of talked a little bit about the 4 documents, and I sort of mentioned avoiding probate and how when you have a will and you have assets in your individual name, those do go through probate. So what I'm going to do now is talk about each of these 5 ways of holding your assets. And I'm going to talk about who controls them while you're living, on your incapacity, and at death, and which ones avoid probate. And we're going to cover today your individual assets, your jointly held assets, your assets that are in a POD or TOD account, and I'll explain what those are. We're going to look at some contractual types of assets and revocable or living trust. Before I get started, I just want to talk a little bit about what is probate. And I've sort of alluded to all the responsibilities of the court filings with the inventory and the accounting, and you need approval for distribution. There are a lot of documents that you supply to the court, and within those documents, a lot of prescribed ways of formatting. So it can be time consuming to do, or expensive if you hire an attorney. So the assets that are basically covered are the assets that are in your individual name. Anything that's not is usually not a probate asset. And the probate process takes a considerable amount of time. So in New Hampshire, for example, when someone passes and the executor files the will, it typically takes about 3 months for that executor to be appointed. And during that process, basically, all your assets that are in your individual name are basically frozen. So if you have an investment account, it's in your individual name, and you pass, nobody can buy or sell. And that can be a little nerve-wracking, particularly in times where the market's very volatile. So that is one of the other advantages of having your assets in a trust while you're living, is if they're in a trust, the very next day the trustee takes over and can manage those assets. The cons of probate are that, as I mentioned, it can be time consuming and expensive. I previously mentioned it's public. And as I was just discussing, it can disrupt the management of the assets. I'd be neglect to say, if I didn't point out, that there are some instances where probate is actually a beneficial thing. So for example, if you have a family that is very contentious, you think they're going to be arguing and potentially suing each other at your death over the assets, then you may want to seriously consider having a probate estate and having your assets go through your will, because the court will settle everything and it'll be final during the probate process, and there'll be no more contesting after that. It will also help resolve the questions about the validity of a will. I've seen attorneys where they have a client whose capacity is somewhat diminished, but they can still make a will, have their assets go through the will, because the court will resolve any questions about that. The lawyers in these cases these days are also typically recording the making of that will as evidence. And some people sort of have their assets in the will because they really have no one else to oversee the estate. They have an executor, but they really don't have anybody they want to continue to management, and they think the judge can do that. And you know, it can be okay to do that if you have a small estate, but if you have a larger estate, I would highly recommend naming a trustee and naming a professional trustee like a bank or a trust company to manage them, because they are just going to do a much better job than the court can. So we talked about the individual assets and how these are the ones that pass through the will and become probate assets. And during your lifetime, you're in control of these. On your incapacity, since they're in your individual name, your durable power of attorney is in control of them. And at your death, the executor takes over and handles the distribution and dealing with the court probate process. There are 4 other types of assets that are non-probate assets. And these are joint assets, the payable on death or transfer on death designation assets, um, contractual assets, and trust assets. And I'm going to talk about each one of these. So jointly hold assets. Most people are familiar with this. You may have a bank account set up with your spouse or your child. During your lifetime, all of the owners control it. They can each withdraw. On incapacity, the joint owner would take over, handling distributions for you and themselves. And at death, they automatically pass to the joint owner and avoid the probate process. And many people think, well, sounds easy. It's a lot easier than paying to have a trust drafted. Why don't we just do this for all our assets? And there are a couple reasons why you may not want to do this. First of all, if you have them set up for example, you and your spouse, and you both die at the same time, then all of a sudden you do have a probate estate. Another reason you may not want to do that is that the estate tax exemption right now is $12 million. So most people don't have more than that. But in 2026, it's going down to the 5.6 million that you can pass on to the next generation tax-free without having an estate tax. And with the use of trust, you and your spouse combined can pass on more than $11 million in 2026 and 22 million now. And if you have a business, then the value of your business is extensive, you may seriously want to consider the trust. Another problem with using joint assets is potentially having a gift tax. So for example, say you don't have a spouse and decide to set up your investment account with your child on it, or your house with your child on it, and then they also own that house or investment account with you. They can withdraw from the investments. And then if you should pass away, you do not get this, you only get a step up with respect to one half of the assets. So, and the step up, if you recall, is when you die, the value of your assets go from the purchase price to the value at your date of death. So there's no income tax upon the sale of those assets at your death. And so you can miss out on that if you add your child as a joint owner. But perhaps even more importantly, what happens if your child has some liability, they go through a divorce, or they get in a car accident and are sued, then all of a sudden, because they're a joint owner on your account, your assets are also subject to being involved in those issues. And as I mentioned, during your incapacity, the joint owner has everything for you, and at your death, it passes to the joint owner. The next type of titling I'm going to talk about are what called payable on death or transfer on death designated assets. They're typically known as POD or TOD assets, and most people aren't familiar with those. And they are essentially a statutory thing where on a bank account, you can name a beneficiary using a POD, or on an investment account, you can name a beneficiary using a TOD. And when you name a beneficiary, those automatically become non-probate assets. And you might want to do this if you, for example, don't have a lot of assets and don't want to go to the trouble of drafting a trust. This enables you to put beneficiaries on most of your assets. There are some assets that are excluded from, for example, in Vermont, you can do a TOD beneficiary designation on real estate. In New Hampshire, you can't yet. There is a bill to sort of change that, but it's been a bill for a few years, so we're all still waiting for that path to pass. With the POD account or the TOD accounts, those are in your name, so your power of attorney holder would handle those if you should become incapacitated, being able to use the accounts to pay bills on your behalf. And at your death, they would pass to those you designate on those beneficiary designation forms. And the next type of non-probate asset I'm going to talk about are contractual assets. And these are assets like life insurance, annuities, retirement assets, basically anything with a beneficiary designation form. And just like with the POD or TOD assets during your lifetime, you control on your incapacity, your power of attorney holder, and at your death, your beneficiary. So one thing you really want to keep in mind is these contractual assets do avoid probate so long as you remember to do a beneficiary designation form, you make sure the financial institution does have it on file, and you don't name your estate. If you name your estate, it does go through your will and become a probate asset. And the final type of non-probate assets are trust assets, and we've talked about those. And during your lifetime, the trustee controls, it can be you or someone else. On your incapacity, the successor trustee, whomever you've named, and at your death, a successor trustee. And basically, it covers everything that is retitled in the trust, which is why it's important to fund your trust, not just go to the estate planning attorney, get it set up and sign it and say, oh, I've got a trust now. If you don't take the next step to go to your financial institutions and change those assets, it doesn't really help you avoid probate. And we've already talked about some of the benefits of these, of it being private, allowing for this continuous management of assets at your death. And it's not being as time consuming or expensive as going through the probate process. The probate process, for me, it's not really the expense involved, but really it's that delay in terms of getting that executor appointed and the time it takes. I mean, typically in New Hampshire, a probate takes at a minimum of 9 months, and I've seen them last 2 years. So this next chart I'm showing is a chart showing the 5 ways to title assets that we just discussed, and the 4 ways of titling that avoid the probate. And in this chart, I've listed who controls the assets during your lifetime, who controls them on your incapacity, and who controls them on your death. And if you'd like this chart, I can send it out to you. I think it's a useful guide for helping you as you go through retitling your assets. So the final thing I'm going to talk to you about is the risk of doing nothing. And this is important. And I find it particularly important for business owners because in my experience, business owners are so time driven in terms of having so much time to run a business that they don't have time to handle their own personal affairs. And this is a mistake because if you handle these in your personal stuff, you're going to be in a much better position. And the first problem of not having the estate plan in place is essentially you lose control. And you lose the control of naming who's going to take care of your assets. You can lose control about how those assets go. You can lose the control of having to have the court involved. And so that is an important aspect. Secondly, particularly if you have a large amount of assets, you can potentially pay more estate tax. With the estate plan, it can be structured to try to minimize that estate tax. You can work out plans to have funds for the estate tax when you need it. And this can be a problem, particularly if you have a family business where all of a sudden your family members are left with this business and they have an estate tax due, and they don't have significant assets outside the business, and all of a sudden they're being forced to liquidate the business to pay the estate tax. So really planning is important. If you don't have the estate plan, you don't have the ability to avoid probate. And we've discussed extensively what's that involved in that. And if you have everything either go through your will or you don't have any estate plan, it can be public information because it will go through the court process. There's also the risk and portfolio management of your assets, in terms of who's going to control them at your death. If you've never done an estate plan, the court's going to have to appoint the conservator. And if getting a executor appointed takes a while, getting a conservator appointed takes even longer. All this mess can be extremely stressful for family members, particularly at a time when they're already grieving. It also provides little protection for your family members. You want to ask yourself, you're growing this business and for yourself and for your family, and what is it all worth? Why are you doing it? Sometimes people get so wrapped up in the business that they forget that, they're really doing it so they have this financial security and protection for their family. And then, as I mentioned, if you don't have an estate plan, there's potentially a conservatorship or even a guardianship if those circumstances arise. So I'm going to open it up for questions, but before I did, I just wanted to point out my last chart. I've put down all my information, and I'm going to leave this up just for a few minutes so that you can have the information to contact me if you have any questions that are more personal that you wouldn't want to ask in this forum. And I also wanted to point out that next week, Ledyard is having a workshop on exit planning for your business. I think this would be a very beneficial thing if you have a business, even if you're not ready to retire or sell your business. It's a good idea to start thinking about how you might want to structure things and how they might look at the end, because it may impact what you do today. And that workshop can be found at www.ledyardworkshop.com, and you can sign up. And the workshop is from 12 to 12:30 every weekday next week, Monday through Friday. If you can't make that time, but you are interested in the workshop, I recommend you still register for the workshop, because so long as you register, you will be sent a copy of the session either that evening or the next day, which you can get into and take a look at. And I also wanted to mention that at Ledyard, we're very big on educating the community on financial issues. So if you do go to the Ledyard Bank website and get into the wealth management and look at the workshops, there are past workshops and videos of those that you can get in and look at. So now I'm going to stop sharing my screen and turn it over to Ernesto to see if there are any questions.
Hi, Valerie. Great job. That was fascinating. And absolutely, there are questions here and some comments. The one comment that just came in, this was very helpful. Thank you so much. So let's start with the question, I think probably a burning question for many people, and one of our audience members asked it. Do you need to have a will and a trust, or is a trust sufficient in New Hampshire?
Well, if you have a trust, you will want to also have a will. And the reason is the will becomes sort of a safety net. They call it a pour over will. And what the lawyer will do is if you have a trust, the residuary clause of the will will say, if there are any assets that go to the will, please send them over to my trust to be distributed. It's called a pour over will. I call it a sort of whoops, I forgot to retitle this asset, and it goes through my will and over to my trust at my death. It does make it probate, but if there's only one or two assets, maybe it's a more simplified probate process.
So if you have a trust, you're going to need a pour over will, or you're going to want one.
You're also gonna need a will, correct?
Would it be better to always have a will and a trust?
So it depends. I mean, ideally it would be great if everybody could have one, but there is a cost to drafting the trust. I do recommend everybody have a will, and you know, even people without assets may want to consider having a trust. For example, the case that comes to mind is many young parents take out life insurance and they may have, a $500,000 worth of life insurance. So that way, if something happens to them, their children have enough money to live off of. In that case, even though they don't have assets, they may want to have a trust and name the trust as beneficiary of that life insurance policy, so that if they should both pass away, they have that money going into a trust. They have someone selected to manage it as the successor trustee from when they're gone, so that their children are well taken care of when they die. So it really is, you really have to look at the individual situation. And I think when you go to an estate planning attorney, you really want to sort of ask the question, I come in for a will, would you recommend I have a trust? What are the pros and cons, and how much does it cost to do one? To sort of make those decisions.
Okay, thank you. Another question uh, we have here is, should you put your bank accounts in your trust? I've been told both ways, that you should because you can avoid probate, but also that you should not, because if you are incapacitated and your trustee needs to manage your affairs before you die, that person cannot get at your money to pay your bills, etc. So it restricts them from being able to help in that way when you might most need it.
So with the trust, as I mentioned, you name a successor trustee, and that successor trustee that takes over when you're incapacitated would then become the person that pays your bills if it's in your trust. So if you don't put it in the trust, the power of attorney does it. If it is in your trust, the successor trustee does it. Oftentimes, the power of attorney and the successor trustee can be the same person. So you could, I would think it would be better to have it in your trust, unless you, in your trust, and that successor trustee can take over, because not only does the successor trustee take over, but you also avoid the probate. And the one thing you do want to consider is, say you have a bank account with you and your spouse. When you put it in the trust, the trustee is the person that controls. So if you want your spouse to be able to withdraw money and write checks, then you really want to name your spouse as a co-trustee with you on that.
Okay. Does a revocable trust have a separate EIN tax number?
So that's a really good question. During your lifetime, so long as you are a trustee or your spouse is a trustee, you do not have a separate EIN number. I liken a trust to sort of being a legal container or a wrapper, and you just sort of pour your assets into it, and while you're living, you control it, and it's taxed to you just as though it were not in the trust. So there's no tax implications. At your death, the trust becomes irrevocable and it cannot be changed. And at that point, you do need to apply for an EIN, and it becomes a separate tax-paying identity. and there is a separate fiduciary income tax for trusts. You'll be happy to know in New Hampshire at the state level, there is no fiduciary income tax for trusts, which is why New Hampshire is a great place to actually create trusts.
Hey, questioner asks, my wife and I are generally on all documents as owners with equal access. She would be my agent for all aspects. How does this affect your advice? Of course, we'll need to handle case of both of us deceased or incapacitated.
Yeah, I mean, I think if you set up your documents and you're both on them and you're both agents, that's great. You do want to think about if you have the trust or your will, setting up a successor, executor, or trustee, so that if, for example, your spouse predeceases you, then you have another person in place to handle things. But that is often the way that it is handled, and that's a great way to do it.
A irrevocable trust question. If my house is in an irrevocable trust, must I pay rent to the trust?
So it depends what kind of trust you have. It sounds like you might have a qualified personal income trust. Um, and in that case, or a QPERT, you set up your house in a trust, and essentially you give your house away, and the trust owns your house, and you live in it. And since you no longer own your trust because it's irrevocable and it's a separate tax-paying entity, you must pay rent to the trust to live there. And the reason for doing that is if you have a lot of assets and are trying to move some assets out of your name, either for estate tax purposes or perhaps for Medicaid planning, this gets the house out of your name. So it's not going to be subject to estate tax. It's not going to be subject to the Medicaid recall. But the downside to doing so is that you must pay rent because you no longer legally own that house.
Hey, we have another question from the audience. Can I designate my LLC as a POD asset?
So if you have an LLC, many business interests are by definition non-probate because they're separate tax-paying IDs. You could, for example, put your LLC in a trust if your attorney deems it necessary. I've never heard of anyone putting an LLC into a POD or TOD. I would have to look at it to see if it can be done. Off the top of my head, I think it needs to be an individual, but I would need to confirm that. So you might, if you've got an LLC and you have a trust, or you go to an estate planning attorney, particularly with these business interests, you want to look at the best way to structure them. Some like a Corp C, you can put the shares in the trust that you have, and some business interests you can't put in trust, and there's no way to avoid probate. So ironically, estate planning attorneys are often partners of a law firm, which are professional organizations, and professional organizations by definition, only individuals can own them, so therefore they cannot be put in trust. So it's quite ironic.
Do you name your business in your trust to go to someone upon your death, or is there something different? Example, operating agreement for an LLC.
Yeah, so if you have an LLC or a partnership, the partnership usually spells out what happens to those assets, and the trust does not control those assets. It's usually the partnership agreement or the LLC agreement. But again, you should check the answer to all these questions. You should check with your own attorney, because what I'm saying here really isn't legal advice. It's just sort of guidance on what sorts of things for you to look at, what to discuss with your attorney so that they can take a closer look at everything.
Okay. One thing that you mentioned earlier in the discussion was that if you lose your will, the court assumes you've destroyed it, or if you can't find it. What happens then? Does the process continue as though you've never had a will? And especially, what if, I mean, maybe this is a stretch, but maybe not. What if somebody loses or the documents destroyed in the same situation that perhaps causes their life to end, and so they're not there to recreate it? What happens?
So it's as if you die without the process of getting an administrator appointed and goes through the intestacy statute. So, I mean, if the original will is destroyed, I mean, it's why you put the original will in a fireproof container, for example, and and it is, you could have a copy of it elsewhere, and it is possible that I suppose your attorney could apply to the court and certify that it's exact true original and put the circumstances, like for example, if it was a fire or something. But again, very may not work just because it's assumed. You can destroy a will at any time, and destroying the will is one way of revoking the will. And so if it doesn't exist, it's assumed to not be what you intended.
Would you recommend keeping a will in like a safe deposit box?
Yeah, I think a safe deposit box is a good idea. Ideally, you want to have a joint person on that safe deposit box, but most banks will allow the person that's a family member, or, come in and review the box to see if the will is in there. They will open it up just for the purpose of finding the will.
Okay. It's kind of a macabre or slightly morbid thought, but it seems really important. So thank you. As we come towards the close and the top of the hour, I was wondering if you could maybe talk about if anything has changed in tax law over recent years that's of interest, that you think is a significant change, or anything that's on the horizon that you're expecting to change.
Well, I guess I would say since 2004, the laws, the trust laws in both Vermont and New Hampshire have been completely revamped. And they've been revamped in a very positive way, particularly in New Hampshire. You can do things like set up self-settled trusts so that not all, but a portion of your assets are not subject to creditors, say, should your business go bankrupt. You you can set up dynasty trusts in New Hampshire, where it used to be trusts had to terminate after a certain number of years after you died. And I won't go into the complications of explaining how they determine that, but today you can set up a trust that lasts indefinitely in New Hampshire. So, if you have a business and you want to put your business in the trust and have it continue for your descendants indefinitely, you can do that. So those are just a couple of examples of some of the ways that trust laws in New Hampshire has been modernized. And again, it's a great place to have. It's sort of become the Delaware of trust law, along with North Dakota. So
So New Hampshire's the place to do it.
yeah, and it's important to note, your will need to be state specific. Your healthcare power is state specific as to where you live, and your durable power of attorney. But your trust can be in any state, so you can have a trust in any state, and to for example, to take advantage of the no income tax in New Hampshire, I believe you do have to have a New Hampshire trustee on it. But I think that other than using New Hampshire law, that's pretty much the only requirement.
Thank you. That's leaving us with another reason to love New Hampshire. Um, well, thank you, Valerie, and thank you to Ledger Financial Advisors for sponsoring this. Thank you, everyone who joined us today. We really appreciate your presence. The recording of today's presentation will be available on nhbr.com, and you'll be able to review any of this at your leisure. So once again, thank you, Valerie. I'm Ernesto Burden, publisher of New Hampshire Business Review. It's been my pleasure to host today. I learned a lot, and I'm sure that all of you did as well. Thanks, Valerie.
You're welcome.
Have a
Bye-bye.
great